Picture this. You're driving home late at night. You see those flashing red and blue lights in your mirror, and your stomach drops. You've done nothing wrong, but you know how quickly an ordinary stop can spiral. The officer walks up, asks for your license, registration, then starts probing deeper. Where are you coming from? Do you have anything else you'd like to show me? Suddenly, it's not just about traffic anymore, it's about control. And right now, you need to know exactly what you are not required to hand over. Because here's the truth. There are 5 specific documents police officers often ask for, and sometimes even demand, that you are under no legal obligation to reveal. And if you don't know these boundaries, you risk volunteering evidence against yourself, even when you've done nothing wrong. I'm a lawyer. I've represented clients who thought they were just cooperating and ended up handing the police the rope used to hang their own defense. So in this video, I'm breaking down each of these 5 documents, what they are, why police want them, and what the law actually says about your right to withhold them. Let's start with the most common trap, your cell phone contents. Your phone data and unlock code. During a traffic stop or an arrest, officers may ask, or even order, you to unlock your phone. They might say, if you've got nothing to hide, go ahead and open it. But legally, your phone is not just a device. It's a vault, a digital extension of your mind. It contains your private messages, banking apps, location history, photos, and cloud access. Here's what the law says. Under the Fifth Amendment, you cannot be compelled to provide something that communicates the contents of your mind, meaning you don't have to disclose a passcode, a PIN, or a pattern unlock. Why? Because giving a code is considered testimonial evidence. It reveals knowledge stored in your memory, and the Fifth Amendment specifically protects against being forced to testify against yourself. Now, some officers try to sidestep this by saying, just put your thumb here, or use Face ID. That's where things get tricky. Biometric unlocking, fingerprints, facial scans are treated differently in some jurisdictions. Courts have ruled both ways. Some say biometrics are like keys, physical identifiers, not testimony. Others say forcing someone to use their finger or face is functionally identical to forcing them to confess. Here's the principle you need to remember. You never have to unlock your device or share your password voluntarily. If police want access, they need a search warrant that specifically names the phone, describes what they're looking for, and identifies why that data is relevant to a criminal investigation. Without that warrant, any search is unconstitutional under the Fourth Amendment's protection against unreasonable searches and seizures. Why it works? The Constitution draws a line between physical evidence and testimonial evidence. Physical items, like fingerprints or a blood sample, can sometimes be taken with a warrant. But mental content, like knowledge, memories, or passcodes, cannot be compelled. That line exists to prevent fishing expeditions through your private life. Never unlock your phone just to get it over with. Once an officer is inside your phone, the scope of exposure is unlimited. Your private photos, messages, calendar entries, and even deleted data become fair game. And anything found can be used against you, even if it's unrelated to the reason you were stopped. Remember this phrase, I do not consent to any searches of my phone or electronic devices. Then stop talking. Silence is your protection. Now let's go deeper. Medical records or prescription documents. Suppose you're stopped, and an officer notices prescription bottles in your car. They ask, what's this for? You got a prescription to prove that? It's a common phishing tactic. They want to establish probable cause to look further, maybe even run toxicology tests or call in drug enforcement. But here's what most people don't realize. Your medical records are protected under federal law, specifically the Health Insurance Portability and Accountability Act, or HIPAA. Under HIPAA, your health information, including prescriptions, doctor's notes, diagnoses, or treatment history, is considered protected health information. Law enforcement can't simply demand it without a warrant, subpoena, or your written consent. So, if an officer asks, can I see your prescription paperwork? You have every right to say calmly, that's private medical information, and I don't consent to sharing it. You are not refusing to cooperate. You are invoking your federal privacy rights. Now let's address what police can do. If they have reasonable suspicion that the pills are illegal, for example, they're not in a labeled bottle or appear counterfeit, they can seize them temporarily to verify legitimacy, but they cannot force you to reveal your condition, your doctor's name, or your dosage history. Those details require due process, either a court order or a warrant supported by probable cause. Why it works? HIPAA doesn't just protect patients in hospitals. It applies anywhere. The law restricts disclosure of medical information by healthcare providers and by you, unless you waive your rights. The Supreme Court has repeatedly recognized the right to medical privacy as part of the broader constitutional right to personal autonomy. Here's where people get trapped. They think just explaining will help. Oh, that's for my anxiety. It's a muscle relaxant from my doctor. But the moment you volunteer that information, it's admissible. The officer can note it in the report, connect it to your physical condition, and later argue you were under the influence. What was meant to sound harmless can be twisted into probable cause. The best response? Stay calm. Be respectful, but don't surrender your rights. Say, "Officer, that's private medical information. I do not consent to share that without a warrant." That one line can make the difference between walking away or ending up in a system you never belonged in. Let's move to the third document, one that gets countless drivers and homeowners in trouble because it looks harmless, but it's actually a setup: financial records and bank statements. Problem: officers sometimes use financial questions to establish motive or credibility during investigations. You might be stopped for a simple traffic violation, but if the stop escalates, say they suspect money laundering, fraud, or illegal activity, they may casually ask, "Do you have any receipts, cash records, or statements to prove where that money came from?" It sounds like a harmless request, but it's not. Because your financial records are among the most legally protected categories of personal information under both federal and state law. The Right to Financial Privacy Act of 1978, RFPA, specifically limits the government's access to your financial data. This includes bank statements, deposit records, wire transfers, or even check copies. Under the RFPA, a federal agency, including law enforcement, cannot obtain your financial records without one of three things. 1. A judicial subpoena authorized by a court. 2. A search warrant based on probable cause. 3. Your written consent. If none of these apply, the officer's request is a bluff, a psychological tactic designed to make you volunteer information that would otherwise require a warrant to obtain. And once you hand something over voluntarily, it no longer enjoys the same constitutional protection. Courts treat it as a waiver of your privacy rights. That means your own cooperation can eliminate your legal defense later. Solution: if an officer asks about your finances, your bank activity, or requests any kind of financial documentation, the safest, most lawful response is, "Officer, I don't consent to providing personal financial information without a court order." Say it clearly, calmly, and once. Then stop talking. Don't explain why you don't want to share. Don't justify, just assert. Why it works. The Fourth Amendment protects against unreasonable searches and seizures of both physical and digital property, including financial data. The RFPA reinforces that by requiring due process before any such records can be accessed. When you stand on that right, you're not obstructing justice. You're demanding that the law itself be followed. Here's what's crucial: law enforcement can still ask for consent. They often do this precisely because they don't have enough probable cause to get a warrant. The entire tactic hinges on intimidation, a tone that suggests refusal equals guilt. But the Constitution does not punish silence. It punishes self-incrimination. There's a phrase I tell my clients: never surrender what the law already protects. Your bank statements, your transaction history, even Venmo screenshots, all of these reveal patterns of behavior, associations, and private decisions. The state has no right to that insight without judicial oversight. The only time you are required to provide limited financial disclosure is when a court orders it. For example, during probation, tax investigations, or court-ordered restitution proceedings. But on the side of the road, during an interrogation, or at your doorstep, no, you are under no obligation to hand that over. Now let's talk about another category that triggers confusion, one that officers frequently use to extract context, or so-called clarifications: written statements or personal notes. Problem: during stops, searches, or arrests, officers sometimes ask to see what you've been writing. That could be a planner, a notebook, or even a piece of paper left in your car. They might justify it as checking for relevant evidence, but what they're actually doing is fishing for self-incriminating material. Any written word they can twist into intent. Written materials are a minefield. Maybe you wrote down a reminder like "meet with Jay about deal" or "get cash ready." In the right or wrong context, that could be spun as evidence of conspiracy, premeditation, or illegal conduct. Under the Fourth Amendment, written documents are protected from unreasonable search and seizure. But under the Fifth Amendment, they're also shielded as testimonial material, meaning anything that reveals the contents of your mind or intent is protected. That's what makes this category doubly powerful. It's both property and testimony. Solution: if an officer asks to read, photograph, or take your personal notes, the proper response is, "Those are private written materials. I do not consent to any search or seizure without a warrant." If they insist, remain silent. Do not grab or hide the documents. That can escalate into obstruction. Simply stand your ground verbally. Why it works. The U.S. Supreme Court, in cases like Boyd v. United States, 1886, and Anderson v. Maryland, 1976, has affirmed that personal papers cannot be seized and used as evidence if doing so violates both the Fourth and Fifth Amendments. The key factor is whether the content reveals the author's thoughts or mental processes. If it does, and most written notes do, they're considered testimony testimonial and thus protected. Now, here's what officers may attempt. They'll frame the request as helping your case. They'll say, if your notes back up your story, we can clear this up right now. Don't fall for it. That's a deceptive interrogation tactic. They're trained to leverage your natural desire to appear cooperative. But in law, cooperation is often indistinguishable from confession. Remember, even if you believe your notes are innocent, you cannot predict how they'll be interpreted once they're out of your hands. An officer sees "check the safe," and suddenly you're linked to an alleged theft. Context vanishes once evidence changes possession. That's why lawyers repeatedly warn, never volunteer documents. Police can ask for anything, but they can only take what the law allows. And if you don't know that line, they'll push past it every time. Another layer of protection applies here, the exclusionary rule. If police seize private documents without a valid warrant or probable cause, anything derived from that illegal search, any statements, confessions, or follow-up evidence, becomes inadmissible in court. That's not a loophole. That's constitutional design. It's there to ensure that officers follow procedure, not impulse. But remember, you can only invoke that rule if you didn't consent. Once you give permission, the search becomes lawful. That's why the word consent is the most dangerous word in police interactions. Once given, it can't be taken back. I want you to understand the psychology here. When an officer stands before you, uniformed and armed, their authority feels absolute, but legally, it's bounded. They're operating under a system of permissions. They must earn each level of access through lawful justification. Every time you say, "I do not consent," you're reminding them of that boundary. Now, some people fear that asserting their rights sounds confrontational. It's not. It's procedural. The calm tone matters more than the words themselves. Confidence and composure disarm aggression. Panic invites escalation. That's why I keep emphasizing, you're not refusing to cooperate, you're choosing to comply with the law as written. By this point, you've learned 4 categories of documents: your phone data, medical records, financial statements, and personal writings that remain firmly under your control unless a judge says otherwise. But the 5th one, the one we'll cover next, is the most misunderstood, because it's the one officers use to make people hand over not just documents, but their freedom. The one that gets more Americans into legal jeopardy than any other. Number 5, written consent forms or waivers. Problem: you're pulled over, questioned, or approached at your home. The officer says, if you'll just sign this, we can clear things up. Maybe it's a search consent form, maybe it's a witness statement acknowledgement, maybe it's a property release or incident confirmation. It sounds administrative, harmless, procedural, but it's not. What you're being handed is a contract, a legally binding waiver of your constitutional rights. Most people don't realize that signing anything during a police encounter is voluntary, unless you are being formally booked, charged, or subpoenaed. These consent forms are tools designed to turn your voluntary cooperation into legally valid permission. Once you sign, it transforms what would otherwise be an illegal search into a lawful one. Let's break it down. There are 2 key types of written waivers you'll encounter in the field. Search consent forms. These grant officers permission to search your vehicle, home, or belongings without a warrant. Voluntary statement acknowledgements. These confirm that you've spoken or provided written information without coercion. Officers are trained to frame both as routine paperwork. They'll say things like, "We just need you to sign this so we can document that you cooperated." This is just a formality and nothing to worry about. But once your signature hits that page, it becomes evidence of consent, a powerful shield for them, and a massive vulnerability for you. Solution: unless you are ordered by a judge or advised by your attorney to sign, never sign anything presented by law enforcement on the spot. You have the absolute right to decline. The correct phrasing is simple and calm. "Officer, I do not consent to sign any documents without legal counsel present." That single sentence protects you from accidentally authorizing a search, a seizure, or a confession. Why it works. Under the 4th Amendment, consent searches are one of the biggest loopholes in constitutional protection, but they only exist when you agree. The U.S. Supreme Court, in cases like Schneckloth versus Bustamante, 1973, established that consent must be voluntary, not coerced, intimidated, or tricked. The moment you say no, the officer must rely on probable cause or a warrant to proceed. And here's the deeper layer. When you sign a form, you're not just waiving your 4th Amendment rights, you're potentially undermining your 5th Amendment protections too, because by confirming that your cooperation was voluntary, you make it harder for your lawyer to later argue that you were under pressure or didn't understand what was happening. That's why I tell clients never sign anything under stress, fatigue, or confusion. In law, voluntary doesn't mean calm, it means uncoerced, but the burden of proving coercion is on you. If you sign, the state presumes you understood and agreed. Now, let's go a layer deeper, because understanding why this matters transforms your behavior under pressure. When you're your adrenaline spikes, flashing lights, uniformed presence, commanding tone, your brain shifts from the prefrontal cortex to the amygdala. That's your fight or flight response. Your reasoning narrows, your recall shortens, and your instinct is to comply quickly to make it end. Police are trained to recognize this shift. It's why they use time pressure, silence, and repeated questions. Subtle cues that push you into compliance mode. They know that the more you want it to just be over, the more likely you are to say, fine, or sign whatever's put in front of you. The key is to train yourself to pause, breathe, let silence work in your favor. You're not being rude. You're reclaiming control over the one thing that matters most in these encounters: time. That's what the fifth document, the consent form, represents. It's not paper, it's the transfer of control. Let's recap everything so you walk away with a clear, bulletproof understanding of your boundaries. The 5 documents cops can't force you to reveal. 1. Your phone's data or passcode, protected under the 5th Amendment, testimonial evidence, and 4th Amendment. Privacy of digital property. Never unlock your phone without a warrant. 2. Your medical records or prescriptions, protected under HIPAA and federal privacy laws. Never disclose health information without a warrant or subpoena. 3. Your financial records, protected under the Right to Financial Privacy Act, RFPA, and the 4th Amendment. Never provide bank statements or transaction details voluntarily. 4. Your personal notes or written statements, protected under both 4th and 5th Amendments. Never let officers read, photograph, or take your private writings without a warrant. 5. Any written consent or waiver, governed by Schneckloth v. Bustamante, 1973, and fundamental 4th Amendment law. Never sign anything without a lawyer present. Here's what ties all of this together. None of these protections are automatic. The Constitution doesn't enforce itself. You have to invoke it. The officer's job is to collect evidence. Your job is to protect your rights. When you stay calm, assert boundaries, and withhold consent, you are not being defiant. You are fulfilling the legal design of the system. The courts expect citizens to know and assert their rights. That's how checks and balances stay alive. But knowledge alone isn't enough. You must condition your reactions before you're in that situation, because when the sirens flash and the adrenaline hits, your body will default to training. So here's the mission. Train yourself to speak from principle, not panic. Say it with me. I do not consent to any searches. I do not consent to share private documents. I do not consent to sign anything without counsel. That's not rebellion. That's discipline. Now, if you take one thing from this video, let it be this. The calm person controls the encounter. When you know where the legal lines are drawn, fear loses its power. And that's what I want for you. Control through clarity. Because the law doesn't just protect those who know it, it empowers them. So next time someone in uniform tries to convince you that cooperation means surrender, remember this. Cooperation is lawful respect. Surrender is silence without understanding. Never confuse the two. You are not powerless. You are protected if you know how to stand within those protections. And if this breakdown helped you feel more confident, share it. Knowledge only matters if it circulates. The more people who understand these 5 protections, the fewer citizens end up criminalized by confusion. Stay calm, stay respectful, stay sovereign. I'm here for you, and this channel exists to give you the law before you need it, because once you're in the moment, it's too late to learn it.